And we'll bring it to you. Opening statements just moments away. He tweeted earlier again that he was excited about the opportunity to remind the American people today that there was no collusion, no obstruction, but we will see what the House Democrats have to say about that. We do have the chairman now speaking. Let's listen in.
Unfortunately, we learned last night that the White House is blocking the first two from even showing up and tightly limiting the third. The White House has no authority, legal or otherwise, to give these orders. We had wanted these three individuals to testify before the committee and the American people because they are critical witnesses to the incidents of obstruction of justice laid out in the Mueller report. In at least 5 of those episodes, evidence laid out in the special counsel's report established that all the elements of obstruction of justice were met. Today, despite the roadblocks the White House has thrown up, we will focus on one of the most concerning of those 5 episodes. It is the President ordering the Attorney General, through Mr. Lewandowski, to stop the special counsel's investigation into the President and his campaign. As the report detailed, Mr. Dearborn was enlisted as part of that effort as well. Mr. Porter has other critical evidence regarding obstruction. As our hearings with the special counsel and other outside experts established, anyone else involved in these episodes of obstruction would have been charged with a crime. Anyone else. Let that sink in. The President knows this, and the White House is intent on preventing the American people from hearing the details. So it is no surprise that the White House blocked 2 of our witnesses, Mr. Porter and Mr. Dearborn, from showing up at all today. On behalf of the President, the White House and the Department of Justice are advancing the same spurious legal doctrine they did when this committee called on the most important obstruction witness to testify, former White House counsel Don McGahn. They claim Porter and Dearborn, like McGahn, are absolutely immune from testifying before Congress. There is no such thing. The only court ever to consider this purported absolute immunity doctrine totally rejected it. That is why we have gone to court in the McGahn case to set it aside. What is happening today is more troubling than McGahn's failure to appear, because even if we apply DOJ's own made-up rules of absolute immunity, I question how Mr. Dearborn fits under those rules. According to DOJ opinions, absolute immunity applies to, quote, the President's immediate advisors who serve as the President's alter ego, close quote. To extend this already dubious doctrine to someone like Mr. Dearborn, who is far more removed from the President than McGahn, is a dangerous new stretch. I think we should call this what it is, an absolute cover-up by the White House. Mr. Lewandowski is here and has vital information about presidential obstruction of justice. The White House wants to limit our and your ability to hear it all. Mr. Lewandowski was called alone, one-on-one, into the Oval Office on June 19, 2017, and again on July 19, 2017. And the President did something I find startling. He dictated the speech to Mr. Lewandowski, a speech not for Mr. Lewandowski, but for Attorney General Sessions to deliver. Then Attorney General Sessions. He secretly told Mr. Lewandowski to put the following words in the AG's mouth, quote, I am going to meet with the special prosecutor to explain this is very unfair and let the special prosecutor move forward with investigating election meddling for future elections so that nothing can happen in future elections. That quote is from Volume 2, page 91 of the Mueller report. As the Mueller report found, limiting the investigation to future elections would have cut off the investigation of any past conduct and struck at the heart of the special counsel's mandate. It would have ended the investigation of the President's conduct. The evidence found by the special counsel met all the elements of obstruction of justice. Mr. Lewandowski was nervous about this demand from his former boss, as he should have been. It raised serious questions about criminal conduct. He was recused, forbidden from doing anything regarding the Mueller investigation. He was certainly not allowed to curtail it. So Mr. Lewandowski tried to surreptitiously meet with the AG. When that failed, he tried to pass the buck to Mr. Dearborn. Mr. Lewandowski gave Mr. Dearborn the script that had been dictated by the President, all while telling the President that he would follow through on the President's orders. So that is what we want to try to learn more about today. As we learned with Special Counsel Mueller, witness testimony is critical to any investigation. But the White House does not want us or the American people to hear this story in full. Late yesterday, the White House sent us a letter claiming that Mr. Lewandowski's conversations with the President, quote, are protected from disclosure by executive branch confidentiality interests. close quote. They say he may testify about presidential communications that are already disclosed in the Mueller report, but no more. They make that claim despite the fact that Mr. Lewandowski was at all times a private political operative, apparently was not offering advice of any kind, the usual prerequisite for executive privilege, and was enlisted for apparent wrongdoing. No court has ever said that the president is entitled to confidentiality under these circumstances. Indeed, the Department of Justice has said executive privilege should not be invoked to conceal evidence of wrongdoing on the part of executive officers. The White House is advancing a new and dangerous theory, the crony privilege. It makes absolute immunity look good by comparison. Where are the limits? This is a cover-up, plain and simple. If it were to prevail, especially while the Judiciary Committee is considering whether to recommend articles of impeachment, it would upend the separation of powers as envisioned by our founders. And today's cover-up is part of a pattern of the White House blocking Congress. The president announced his desire to, quote, fight all the subpoenas, unquote. The White House's obstruction of Congress ranges across nearly every committee and virtually every investigation of the administration, whether related to children in cages, botched security clearances, or their failure to defend the country from ongoing attacks by a foreign adversary. Well, Mr. Lewandowski, you are here under subpoena. That means you are required to answer our questions, all our questions, completely and truthfully. Our investigation also extends beyond the four corners of the Mueller report. We are looking at corruption and abuse of power more broadly, so we will inquire about other subjects as well. We will not be daunted by the cover-up. We intend to secure accountability for any wrongdoing, because no one is above the law, not even the President of the United States. I now recognize the ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Well, thank you, Mr. Chairman, and thank you for introducing this hearing, which is now, as you said, under the new rules. You know, it's sort of the old school, the old rules of the new rules, the new rules of the old rules. These rules that were here all along. And yet, here we go again. We're going to say that they're new because we like the packaging. I've never seen a majority so amazed with packaging in all my life. You know why? Because they can't sell what's inside. They can't sell the product. So they just keep packaging it differently. You know, I think we should call, I agree with my chairman, I think we should call this for what it is. It's just another simple oversight hearing. In fact, no, I think it's actually become this. It has become, let's read the Mueller report for audiobook. That's what we become. We had Mr. Mueller here. Had a long day of it. Judging by all accounts, it didn't go real well. For the purpose of what you've proclaimed for over 9 months and almost 2 years, that there's impeachable offenses, as my chairman has said, clearly in the Mueller report. But here's the problem. 17 of the members of the Judiciary Committee have said that they think the president ought to be impeached. So why are we still investigating it? 17, you get some more. The problem is you don't have the votes. You don't have the numbers. And even if you got it out of this committee, you don't have it on the floor. That's your problem. So the thing that we're going to do is we're going to drag this committee through oversight hearings, talking about things that have been talked about ad nauseum, ad nauseum, ad nauseum. We're going to talk about it. We're going to put filters up. We're going to say what it really is or really is not. While in all the things, we're going to try to imply that this president shouldn't be president. You know, it is really interesting to me that we just heard just a moment ago that was said that these made-up rules at DOJ. Well, it's interesting that now they're made-up rules. They wasn't made-up rules when Obama administration used them. Were they made-up rules then? Just asking for a friend. You know, this is amazing. As we come into this situation, the chairman also said that while we're doing this and stopping committees from searching into products like the immigration issue and foreign influence, I just want to remind everybody here watching and everybody here to see the show today, and also to remind the majority that they have complete jurisdiction over immigration. We have complete and total jurisdiction over immigration for the most part. All we have to do is, if you want to fix the border, put a bill up. You don't want to do that. You like this. You like having the press here. You like the cameras because it makes it appear like something's happening that's not. But the real thing, and it's coming out, the American people are starting to get it. They're starting to get it that if you're just howling at the wind, you're not doing anything. You're making them think you are, but you're not. So don't tell me, don't bring to me immigration anymore that you want to deal with it. You just want to bring administration officials in here and yell at them because what you don't like is happening. And I agree, we need to fix it. Bring us a bill, bring my bill, bring your bill, but do something about it. Quit talking about it. Foreign influence. The only real thing we all agree on in the Mueller report was foreign influence from Russia, but yet where's the bill? Where's the bill? Where's Waldo? Where's the bill? We don't do anything about it. We like to talk about it because we think it makes the president look bad. Because that's the implication we've been giving for 2 years. Unfortunately, we also don't really want information in this committee either. If we did, we'd work like the Intel Committee had done. You know, we've had that issue before. They'd have to actually work with witnesses to get them to come in. Mr. Lewandowski, I believe, said he'd come without a subpoena, but yet we subpoenaed him anyway. Because it looks, as I was told earlier this year, from the chairman's perspective, a subpoena is a start of a dialogue. Not according to Black's Law Dictionary, but who cares? We're just the Judiciary Committee. This is the problem we're having. This committee does not want to interview Don McGahn behind closed doors. They want him in front of everybody. They want to do this out front. They don't try to actually get information. That's what real oversight is. Real oversight is trying to get information. But we don't do that. I understand it's tough making a promise and not keeping it. I understand. All of us in this room can relate to a time when we made a promise and we couldn't keep it. My majority made a promise. We'll impeach him. We'll investigate him. For most of them, it happened in November 2016 because they couldn't believe that Donald Trump won. And they still can't get over it today. So what do? We have public hearings, lots of flashbulbs, embarrassing the president, not gathering facts, not investigating, not doing oversight. This is certainly not being fair, but we like to issue subpoenas. We're setting a world record at that. 40 times faster than the previous chairman. But we don't want any answers because we're not willing to engage in dialogue to get information from folks. And you know how I believe that this is more just wanting to get it here? Is because it's not like Mr. Lewandowski has had silence on this issue. He's testified before Senate Select Committee on Intelligence. He's testified before House Permanent Select Committee on Intelligence. And now he's also voluntarily testified for the special counselor, by the way, Mr. Mueller. And we've had access to all of his summaries of his testimony. This is not new. But yet it is new because it's another time to rehash an old story. You know, this is the fall. This is when the ABC and NBC and all the broadcast folks, they bring out their new shows. This isn't the summer rerun season. We should get into something new, but I just want to show you one last thing before I turn it back over and, you know, we'll get the popcorn and the show going. The Judiciary Committee is the Judiciary Committee for a reason. It's because we oversee the court system. And for any person who has actually been here, and actually an attorney in this room who's actually appeared before a judge is pretty stickler for rules. And I just want to point out something. It may be trivial, and I know some will laugh and some won't care, but for some of us it does matter. The subpoena today for Mr. Lewandowski and the others said 10 a.m. this morning. This just shows you how impulsive and poorly designed this entire sort of faux impeachment charade we're doing. The subpoena is not even properly. The subpoenas were here for all three to compel them at 10 o'clock this morning, but today's hearing's at 1, not 10. The witnesses lack appropriate notice for the hearing today. That's a simple, basic subpoena issue. But we're the Judiciary Committee. I can understand this, and no offense, natural resources, I can understand if they get it wrong. Or transportation. I don't understand how judiciary gets this wrong. The chairman wants to hold people in contempt for not showing up. Try to enforce this in court. Because there's no extra letter. There's no clarification of time. And when I was given a subpoena for my client to appear in court, what time do you appear in court? Whenever you feel like it? No, at the time it says. Unless the court or the officer giving the subpoena says differently. The chairman's only option for success here is to issue, well, we could do this, I guess, because we've wasted enough time on other things. We reissue new subpoenas with a new date, new time, and hold a new hearing. There's probably a date somewhere in October we haven't filled up with this mess somewhere. So with this, here we go. Mr. Chairman, there's so much that we could actually do together. There's so much. But as long as we don't have time, we'll continue with rerun season. Popcorn still tastes good. I don't know why we do this. Except maybe we just have maybe a deficiency of flashbulbs. I don't know, because we just like the show.